We came to court as ordered by the court, and we made an application to release our clients on bail, because the Constitution says if an accused person has been in custody for more than 6 months, 180 days, they must be released on bail. That's what we call mandatory bail. And no other proceedings can go on before the consideration of bail. So the court agreed to hear our bail application. And at the end of it, the court did not grant bail, saying that it has no jurisdiction, it should be the High Court. Although the law is very clear that the subordinate court, that is a magistrate's court, can grant bail. The magistrate cited practice directions, practice rules. In law, the supreme law is the Constitution, followed by statute law. Regulations come a distant third. So we did not understand how the magistrate preferred regulations to written law and to the Constitution. Thereafter, we asked on behalf of our clients to have the case referred to the High Court for bail, because that's the order of things. And we pointed out to her the practice rules, regulations she was showing us. Practice regulation number 10 says if 180 days have passed and the magistrate feels she cannot grant bail because the case is triable by the High Court, like in this case, then the court must immediately refer the file to the High Court. She then again turned around. Instead of following the regulations she had followed earlier, she turned around and said she is unable to tell whether they have finished 180 days, therefore she cannot refer the file to the High Court. Then we adjourned again. We were objecting to the amendment of the charges, and we are telling her, stay the proceedings, we go for revision in the High Court. She asked for an adjournment, and we went and saw our clients. Our clients' instructions were, since the court is challenging us to go and file revision, our clients want us to prioritize their freedom and revision. So we have withdrawn to obey our clients' instructions to go and file revision proceedings. In the meantime, we have left court. We do not know what is going on. But our clients' instructions are clear. We cannot proceed against their instructions.
Whatever proceeds without you.
Our clients are there. They have given us the instructions. We are in court because of our clients, not because of the court.
We shall never
we any step is taken by the state before we make our application, which is outstanding since the last time. And it's a command of the Constitution, it's a command of the MCA about the next step in any of the proceedings before you after the expiration of the mandatory remand. So we wanted to proceed with our application, Your Worship, before any other step is taken.
Proceed with it.
Most of that, Your Worship. Your Worship, we pray that you will be pleased to release A1 and A2 on bail in accordance with the provisions of Article 23 of the Constitution. My Lord, Your Worship, in Clause 6 of Article 23 C, where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court, if that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail in such conditions as the court considers reasonable. The operative word here, Your Worship, is shall be released on bail. That what gives this honorable court authority and mandate to invoke these powers to release the accused persons on bail. So, Your Worship, from the record, the accused persons have been on remand since the 20th day of November 2024, well beyond the mandatory period provided for under Article 23, Clause 6, paragraph C. This particular provision is reinforced by Section 76 of the Magistrates Courts Act, which reads as follows, if it may please you, Your Worship. If an accused person has been remanded in custody before his work trial commences, in respect of any offense punishable by death, a continuous period exceeding 180 days. B, in respect of any other offense, a continuous period exceeding 60 days. The magistrate, before whom the accused person first appears after the expiration of the relevant period, shall be released. The magistrate, before whom the person first appears after the expiration of the relevant period, shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in Section 75, unless 1, he or she has, prior to the expiration of that period, been committed to the High Court for trial. Excuse me. Now, Your Worship, from the record, the accused persons have spent over 180 days. That's a fact which is not controverted. And it's also well canvassed in the affidavit of Queen Hira Roscovia, which we filed on record, to bring out the history of this matter and the chronology of the events, right from the time the accused persons were kidnapped from Nairobi on 16th of November and taken through the processes before the General Court Martial on the 20th day of of the same month, November 2024, and remanded to Zira, where they have been languishing up to the present moment. All those particulars, those facts, are gone out in that affidavit, are brought out in that affidavit, which is not rebutted in any way or controverted. Your Worship, on record, on the 31st day of January, the Supreme Court directed the General Court Martial to cease any trial of civilian cases, and that all those matters be transferred to the ordinary court, to the conventional courts, the courts of judicature. And that is the genesis of this matter. And that's the reason we are here. So that is in the chain of the events, right from the time of kidnap to formal charging or indictment, and then subsequently remand, and up to the present moment. So now, Your Worship, here, there are two things we need to emphasize here. After blocking 180 days on remand, two things here are fundamental. Number one, this magistrate court cannot take any other step except for handling the proceedings relating to the release of the accused. No any other step. This honorable court cannot in any way proceed with issues to do with amendment of the charge sheet or any other action be taken except to issue an order of release on such conditions what may deem appropriate. That is number one. The second one is have they been committed before the expiration of the 180 days? The answer is no. And this is the spirit and the letter of section 76, paragraph B1. Unless he or she has, prior to the expiration of that period, been committed to the High Court for trial, prior to the committal. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't host the jurisdiction of this honorable court from going ahead with the mandatory payment. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of the law. We'd like to ask this honorable court, Your Worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was couched this way in section 76. Why this particular provision was couched there? To stamp out persecution, impunity. It's intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution will arrive to that fact that the state may exceed what is actually within the limit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit, the reason there was that limit of 180 days, and the court was given those powers that is once the state has failed to take steps to commit the accused persons within 180 days, first appearance before you as a magistrate. Don't do any other thing. Please just consider releasing the accused persons. And that's what we are asking for, your worship. This honorable court shouldn't acquiesce or be an accomplice in the persecution of the accused person by the state. So the only thing that should be done at this stage is to release the accused person. So in such conditions, you'll be with the Supreme Court.
35C, the command of the Constitution, says shall, and therefore does away with the ordinary bail application, which is made that allows for a discretion. So it is a constitutional command. What the court ought to satisfy itself is that the offense is triable only by the High Court. And that the person who is the applicant has been on remand for more than 180 days before commitment. So I join issue with my senior colleague, Mr. Lupago, that the committal per se does not take back time to nullify the 180 days. The 180 days are a constant. Two, Your Worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made.
Repeat that.
I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application is made. And mindful of the decision of the Supreme Court directed a transfer of the files. What I'm trying to say, Your Worship, is that the process from the court-martial to this court is continuous. There is no break so that the proceedings before the Court of Appeal, the court-martial, are not taken into consideration. So when we stick to the 180 days, Your Worship, the court must take into consideration the date of remand by the General Court Martial, because it is also a court under the Constitution. So that article, Your Worship, again for emphasis, says in case a person has been remanded in custody. It doesn't say, it envisages that a remand can be made by any court of law, or any court as established by law, of which the General Court Martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year, and therefore they are not 180 days, does not hold. Court takes into consideration the time when the remand started to run, count the 180 days. And Your Worship, there is a view that perhaps in matters or offenses tried only by the High Court, the Magistrates Court should not grant bail
because the matter is tried by the High Court only. Your Worship, in the current constitutional dispensation, the Magistrates Court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Tesimana Rosemary, the Honorable Mr. Justice FMS Egonantende, as he then was, Tesimana Rosemary, is criminal revision cause number MSK hyphen 00 hyphen CR hyphen CV hyphen 0013 of 1999. I cite it because it is the current dispensation. Because in that case again, Your Worship, the magistrate had declined to exercise powers and sent the file up for revision on the ground that the matter was tried by the High Court. Your Worship, I beg to read, and I'll avail a copy, what the Honorable Justice Egonantende said. My Lord, it is Your Worship, it's the highlight at page 13. So before I take leave of this case, I must say that courts cannot escape the blame for this unhappy set of affairs in the criminal justice system, which has no remorse for caging up people in penal institutions for unjustifiable periods of time. It would appear that magistrates' courts to which accused persons are first produced before committal regard themselves as no more than, should not regard themselves as no more than assembly line of conveyor belts run by the prosecution. For years on end, the court is content to record endlessly adjournments, etc. But the point, my Lord, the judge said at paragraph 39, that even though a magistrate's court has no jurisdiction to try capital offences, accused persons such charges are brought before it to ensure that, among other things, the accused rights are protected. The courts must be vigilant in doing so by consistently requiring the prosecution to provide information regarding the investigation. What we are pointing out here is that the constitutional command says that once the accused person is emphasizing their rights, once the matter is before it, even for capital offences, this court cannot feign not to have jurisdiction on ground that the offence is of a capital nature. In Article 23C, therefore, the accused persons contend that they have been on remand by order of the court so established under the Constitution, the GCM, for a period exceeding 180 days. If I count well, Your Worship, today there should be 196 or thereabout. and that the matter which is before this court now is because the accused persons are exercising their right to mandatory bail as commanded by the Constitution. The onus of the court is, upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and were told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge in regard to capital offences. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect to what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In any event, Your Worship, the practice directions of the principal judge and even Chief Justice cannot override the express provisions of the Constitution. We just wish to remind the court, and we are aware that the court is already aware, that the Constitution is the supreme law of the land. Your Worship, Article 2 of the Constitution is clear. Under the subheading Supremacy of the Constitution, states that the Constitution is the supreme law of Uganda and shall have binding force on all authorities and persons throughout Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions they pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Lukwabo, area senior counsel, referred to. We reiterate the prayer that 180 days have elapsed, and as the defense, we shall happily receive the conditions for the mandatory bail, because it is a command that it must be granted.